Welcome to tonight's show. I'm your host and the head of online community here at Housecall Pro, Alexa. Good to see all of you back here again and some new names in here. So welcome to also Roland. Sorry, I'm trying to figure things out with Mel as we're talking. I'm getting distracted. I'm joined by Roland. He is the co-founder of Housecall Pro, and Mel, who's our awesome senior vice president of people. She is joining right now. She's just having a little bit of computer trouble. So for the past 11 weeks, we've been coming at you live at 5 p.m. Pacific time, Monday through Thursday, and we bring you the state of the world. And then we have one main topic or guest. So tonight, as you can tell, we have Mario here, Mario Jaramillo. Did I say your last name right?
Jaramillo, but close enough.
Jaramillo. There we go, Jaramillo. So
we're from San Diego. We should know that La Jolla is La Jolla, not La Jolla.
Gosh, we even talked about this last night too. So Mario is representing Rocket Lawyer today, and I'm sure he'll share his connection there and his story. But we wanted to get Mario on tonight to talk about just legal stuff, things that are going on in the world right now that maybe you have some questions about that a lawyer can answer. So this is your opportunity to ask a lawyer anything within reason. Remember, if it's too specific, we can't answer it, but if there's more general themes to it, we can definitely do that. And hopefully with the questions we've compiled already, it will answer whatever questions you have in your head. So if you're wondering on where to watch these past episodes, just head on over to our YouTube channel, Housecall Pro, and type in, or at the very top, it says Coronavirus Home Service Update, and you will find all of our past episodes there. And of course, make sure you're joined in our Facebook group. I'm going to pass it over to Roland while Mel starts to join in. If she's unable to, we'll have her come on at the end, and we'll just get started with Mario.
Yep, that sounds great. So first things first, we like to share our what we call Trades Health Index. We compile all the data across everyone using Housecall Pro to show you guys some good news. We are now literally at almost exactly the same point we were in 2019. So recovery on scheduled jobs, which is a leading indicator, is almost, that's off by 1%. No, 50 basis points. And then completed jobs, getting real close. I expect this by this time next week to be a little bit further. If you want to, you can sort it by your own industry and or your own state. So you can dive down and look at the data and see how you're comparing to other people. And if your feeling is true, take the data that you have inside of Housecall Pro or whatever else you're using to keep track of your data, compare it a year, and see how you're trending. Also, one thing like we like to do with Mel here is we'd like to look at the Johns Hopkins dashboard. And in here you can see the U.S. world total confirmed cases, 5.7 million, 350,000 deaths. And yesterday here in the U.S., we just crossed the 100,000 mark. Wow. Good news is there are over 400,000 recovered. So this is a cool dashboard, keeps you kind of up to date on the data. These two links we will share in the chat if you guys want to check it out and this is your first time viewing. If not, you've probably seen these links before. So that's the piece on the data. Should I go into some of the updates real quick?
Sure. Let's go ahead and do a few updates, and then we'll get started on the main portion of this.
All right. So let's talk a little bit about face coverings. I've got mine right here. It's kind of cool. It looks camo, but everybody, it's continuing to spark controversy. Health experts are encouraging everyone to wear a mask while in public because the coronavirus is so extremely contagious. People don't want to have symptoms. They can still spread it. But some businesses are banning masks. So in Kentucky at a gas station, no one allowed inside if they are wearing a mask. In Los Angeles, a flooring store encourages hugs and handshakes. Also seems a little crazy. And in New York, New York Governor Andrew Cuomo says he's signing a new executive order that will allow store owners to deny entry into their business for those not wearing face coverings. So you got two polar sides of the story here. I know Costco recently, I saw they, here in San Diego, kicked some people out. They're walking around without it. So you got two sides of every story. So we're interesting place right now. On the economy side of things, today they released another 2.1 million people filed for the first time on unemployment benefits. So that brings the total to coronavirus-related layoffs to more than 40 million. That's 1 in 4. So that's a pretty staggering statistic. And obviously, we will see what next week brings, but obviously predicting more of that to come. As it relates to the White House, they decided not to release any economic projections for the summer. There's critics, obviously, as always, on both sides, saying the White House should publish their projections in line with the precedent set by prior administrations, regardless of the uncertainty caused by the pandemic. So this is something they're working through, but because of the high number of unemployment filings, we can probably surmise that the economic effects will continue to hit the U.S. hard, especially in these next coming months, as the federal stimulus, where there's a lot of great unemployment benefits, ends at the end of July. So we'll see how that affects things kind of going forward. So let's get down to the nitty gritty. We got Mario on here. We want to make great use of his time.
Yes. So welcome, Mario.
Start billing now? Is this how it works?
I'm like, can you put it on Roland's card? I don't have a company card anymore.
Yeah, you know what? The card got rejected, guys. Could you resend that one? Okay, just kidding.
I'm trying to get my Visa points. Come on Southwest for all the travel that I'm doing.
You know, it's funny you laugh, but that's what I tell clients all the time. They need to retain me, and they go, well, do you take, check, cash, credit card? I go, take all methods, of currency, but if you have a credit card, you get rewards points, stuff like that. So please use it, because the money you pay me, I can't give you an IKEA set, right? Furniture or anything like that.
So Mario, obviously tonight we're doing Ask a Lawyer Anything, some topics that we're going to be covering: basic COVID questions, business issues, contract enforcement, definitely employment law. We're going to talk about partners, subcontractors, and if we have time, some interesting things that Mario is seeing in terms of like landlord-tenant laws and family law at the end. So Mario, to start us off, can you just tell us and our audience a bit more about yourself, how you got to where you are now, the type of law you practice?
Sure, not a problem. Thank you again. Thanks for the opportunity, and hello everybody out there. So I've been practicing law for, going on 22 years, and so definitely quite some time. In fact, I went to USC Law School, and I remember when I was graduating law school back in 97, started practicing 98, that's when we first got email addresses. And when we got our email address, I was like, what is this? I don't want an email address. I don't want people bothering me, and now look, everything's via email, internet, et cetera, all that kind of stuff. And so, the profession has really progressed. When I started practicing, I did the big firm thing. I worked at a couple of firms, initially representing doctors, nurses, the medical profession, defending them on cases there. And then eventually went on to a similarly sized firm, a big firm, representing all kinds of, large companies, small companies, municipalities, insurance companies, a lot of defense work. And then about 2 years in or so, I realized that it just wasn't for me. And not saying that law wasn't for me, but the billable aspect, the long hours, all that stuff, to me, I just realized that even then, early on, I wanted more of a work-life balance. And I've always been pretty good at generating business, fortunately. And so I decided to take a leap of faith and jump out on my own. And I created my own firm, and it grew enormously. I did pretty well, fortunately, at that time. And then I sold it, my first firm in 2004. I got out of real estate altogether. I was very entrepreneurial in my 30s, and I got into the real estate boom, real estate, mortgages, insurance. I had a lounge with full alcohol in Pasadena. Oh, life was grand. And then the recession
2008.
Yeah, exactly. And the recession hit, and it was a very humbling experience. And literally after the dust settled, all I had still was my law degree. And at that point, I didn't want to work for I didn't want to own anything anymore, because I was left holding a bag of nothing. And so went to work for a couple of firms. But what was challenging was that since I was out of the market for quite some time, 6-7 years during the when I sold my firm, I wasn't marketable. I wasn't able to be brought in and be competitive with other attorneys around my level. And so when I went in to start working for firms, they're like, all right, do you have any business? And I go, I'll find it. And so that's where I came across the legal plan world. And so, different legal plans out there. You may have heard of many, but right now, the primary that I service, the one that I love, and an awesome group of people over there is Rocket Lawyer, which is what I'm primarily associated with now. Great group over there. Great for both consumers, business owners, et cetera, et cetera. And so I've been associated with Rocket Lawyer now since 2011, so 9 years. And together we've built what I believe to be a pretty robust legal benefits plan for its members, both, business, consumer, all that stuff. And so we service all kinds of needs. We get from, small mom and pop shops to established companies to individuals looking to get an estate plan done, or people, issues with their landlord, or neighbor disputes, property disputes, easements, contractors. A big hot topic, and I saw it come through on chat that we could address also was, now with the recent change in the law as to what constitutes an independent contractor versus an employee. So that gets confusing for a lot of people now, right? And so, we could go into that. And so anyways, so the enjoyment that I have with the practice and why I got in, initially I got in because my father was a chiropractor growing up and I was supposed to take over his practice, but I didn't like the way attorneys were treating him. So I wanted to be on the flip side of it and be that attorney that treats people the way they should be treated. And so I got into it for that reason. And then eventually just segued into different areas of law, whatnot. And then now, we have 10 offices up and down the state. We have 13 attorneys, hiring more. About 6 staff, hiring more staff as well to meet these pandemic needs, these new inquiries, this new normal, right, that we're all in. And with that new normal come new laws or new interpretation of laws or, trying to understand how the laws apply to you, all that stuff. And we're learning as we go too, because.
Yes. So what you're saying is really interesting. I think for our pros, it might be a good question to cover. So how do laws get passed?
Right. So very, very good question. So numerous ways, and I can only speak to California, right? So I'm a California attorney, that kind of stuff. So it might be different in other states or what have you. But in California, for the most part, there's several ways in no particular order. Laws can be voted in, right? We have elections, we have ballots, and those ballots, depending on what's being proposed, does it succeed, does it not, does it then get codified in the law? There could also be bills passed, assembly bills that turn to law. So one that is a hot topic for likely your viewers is Assembly Bill 5, which is the law that codified, what constitutes an independent contractor versus an employee, which is really what codified what's called the Dynamix ruling. So if you're any of your viewers were to Google search that Dynamix, DYNAMEX, that is what changed everything last year. And that's why our governor codified it into AB 5 because there was a lot of confusion as to how it applies in different industries. And so that's what's going on there. And then there's also laws that are created by what's called case law. And so what some people may know or may not know is that your standard, superior court cases, your small claims lawsuits, stuff that's filed in superior court that's above small claims jurisdiction, that doesn't create law. What creates law is when that stuff gets appealed. And so when it goes to the appellate court or the state Supreme Court, or even in some cases, federal courts or the U.S. Supreme Court, when those rulings come down, if they become published, that becomes law. So there's case law and there's statutory law. And the statutory law comes from ballots and assembly bills, stuff like that. Case law comes from cases regular disputes that people have on a regular basis that get taken up to higher levels.
Yep. And I feel like obviously with case law, once the ruling is passed, there's precedent set. And so based upon that as well, when you go get advice from a lawyer, they're going to start looking across this and kind of giving you a feeling of what you should or shouldn't do based upon, what's happened in the past.
Right. So the law is very fluid, right? So, usually what we try to do, depending on the areas of law that we handle, is we try to stay abreast of those developments. Back in the day, it was by way of journals, paper, print journals, such as what's called the Daily Journal that's still around. And now, of course, it's signing up to different legal, websites or press sites, that kind of stuff that will keep you updated in certain areas of law as things change and as things develop. So it's definitely important that, the attorney that you hire or talk to is somebody that is kept up to speed with the changes, although it can change regularly. And so oftentimes, depending on the issue that we come across, not only do we speak based on our experience and generally how the law works, but then also as we take on the matter, we dive deeper into seeing if there are any changes that could, change our initial opinion on it or something like that.
Mm-hmm. So now that you guys have your little not history lesson, your law lesson, we all got a
Law
refresh.
101, Law 101 refresher course.
So we're going to start getting into some of the questions that you guys asked on Roland's Facebook post, starting with just a basic COVID question. Are we required in law to provide PPE for employees? What can happen if they don't, or what's going on there?
Right. So yes, you are. So, and again, it's everything with COVID is still very fluid, right? Because it hasn't been established law yet, unless it's a federal mandate or a state mandate or what have you. But for the most part, of the general premise, you have to provide your employees with all the tools that they need to be able to conduct, their work in a safe manner. And PPEs hit right in line with that. And so you do need to provide, you can't have, you require your employees to bring in their own stuff. If they do, you have to reimburse them for that. But then the problem is if they bring in their own stuff, does it meet the certain standards that are needed by way of state standards or federal standards as to what is to exist to protect not only them, but to protect their coworkers. And so by not doing so, then if you don't have a safe working environment, then you could fall into a lot of liability issues ranging from OSHA complaints, because a lot of employees now are contacting OSHA and complaining about their work environment if it's PPEs aren't being provided, or if somebody that appears to be sick is not being sent home or is allowed to work or something of that nature. And then along with liability issues, and that would fall right in either into your workers' comp category, where people can make a workers' comp claim, or if it's deemed grossly negligent, meaning that it's a clear aberration of public policy or the like, then it could even be a negligent claim beyond workers' comp, right? And so it's definitely important that PPEs are provided to employees.
I like how also, yes, and Alexa's taking notes and putting the TLDR, the summary of all that. So make sure you guys are getting your PPE equipment to your employees, so not only do they feel safe, but they don't bring any complaints to OSHA, workers' comp, et cetera, because that's something you don't want to get carried into, even though there's, a lot of uncertainty with what is good and what is not. As long as you try doing your best too, that's obviously staying abreast with stuff like this, the news, what's going on, what do we recommend? You just not knowing about it is not a defense. Ignorance is not your friend.
Yeah, exactly.
That's right.
Exactly. And by the way, if I speak too fast, tell me to slow down. Court reporters would tell me all the time, slow down, slow down.
Type fast enough.
Exactly.
We will.
So let's talk about a topic that comes up really often. Obviously, in this kind of contactless world, digital invoicing, using software kind of like Housecall Pro, things like that, our pros are collecting payments more and more online. When they're doing this, what do they need to collect to make sure they're making sure they're getting the right things in order to kind of protect the payment, make sure, chargebacks and things like that aren't happening? What, from a legal perspective, do they need to be thinking about as they're doing this? And they're not really taking cash anymore, because it's even more dirty now than ever.
Nobody wants to touch it, right?
Yeah.
Cash is king. Now it's like somebody gives you cash. No, get that away from me. It's like garlic to a vampire, right? Yeah, exactly. Elbow me it. So double elbow. I can't even. Okay, so very good question. And so several thoughts on that. One is, you can never prevent a chargeback by a merchant, by merchant service provider. Merchant service provider meaning the credit card company, whoever's processing the payment. It just happens. And in fact, depending on what side of the fence you're on it, either a merchant service provider chargeback could either be a benefit or a curse. Why? Because my concern there is that there's no due process in that. There are no set laws on how a merchant is to determine whether or not that was a valid charge or not. Every merchant service provider has their own policy on it. And so you might have a situation where you did everything that you want that was per the services to be provided, everything was great, the agreed upon fee paid, and all of a sudden you get a chargeback. And now you're put on the defensive, and in essence, you're spending time that you're not able to be compensated for to defend yourself on the job that was already performed, right? Mm-hmm. So that can be very, very frustrating for a lot of companies out there. But unfortunately, it is the process on how it works. And so on the merchant processing side of it, when there's a dispute, the most important thing is to respond to it quickly, having proper documentation in place, communication such as, copies of your text messages, emails, your contract, and your invoicing. See, there are different schools of thought on the invoicing. I've had many customers come to me where they're like, look, I just like to keep it simple. I don't want to, too much verbiage will scare off the customer. I just want to get it out there. They agree to this, and we perform services. That's great. The flip side of it is without terms and conditions, then when there's a dispute, what do you have to back you up? Mm-hmm. And so key terms and conditions on an invoice, maybe on the back side. Well, now there's no backside, right? So now it's just an ongoing screen or
digital,
digital, right? And so when you have that and they understand it, you want to have it be an opt-in, right? Not a wraparound, have it opt-in so that they either have read it or they're scrolling through just to click it and get through it. But the presumption is that they've read it, the customer, so that is another defense for you when you're getting that chargeback. Like, no, these are the services I provided pursuant to these terms and conditions. We provided it, we paid, we should be able to, resolve this chargeback in our favor. Now, with that being said, again, a merchant service company is not a judge, right? It's not a court. And so they have their own policies and procedures. And I've heard of situations where you provided all proof available that you provided those services, and then all of a sudden that chargeback is still going against you. What can you do there? Well, unfortunately, at that point, you're going to have to use a court of law at that point, right? And so if you're a business suing an individual or another business, you're in California, you're capped at $5,000 or less. If you're an individual providing personal services, then you could sue for up to $10,000. But generally on business-related matters, you're capped at $5,000 in small claims court. So, sorry, go ahead.
And obviously, to protect themselves, where do they get the best terms and conditions? Like, what's your advice there? Because inside of our, yes, all right, so if they go to Rocket Lawyer, there's a section there where they can go get a template and then get it customized for their particular business.
Right, exactly. Yep. So Rocket Lawyer, has hundreds upon hundreds of sample templates, that tend to fit, a variety of types of businesses or scenarios. And then you go in, it's very simple to use, input your information. My suggestion is when you download it, download it as a Word document, go through it, and then modify it to your own needs. But what's very, very important is if for any reason you get confused, any reason it's a legal term or whatever, please do not assume. Please do not assume. It's in your best interest to contact Rocket Lawyer, say, hey, can you connect me with a lawyer? I'd like to have this document reviewed so I can understand this correctly, make sure it's accomplishing what I want to accomplish, and then Rocket Lawyer will connect you with somebody like me or another attorney that's on panel, and then we'll go over that document with you. Very, very important. Yeah. I've had cases, just an important example, I've had cases that have cost millions of dollars in legal fees because the parties didn't use an attorney, used a software or a doc, and chose to change key provisions without having a lawyer review it. And it wasn't through Rocket Lawyer, it was before Rocket Lawyer did, it was software, that kind of stuff. But costly mistake,
Yeah, don't just go copying and pasting stuff, guys, because you guys are going to end up shooting yourself in the foot. So always get that second pair of eyes, because you don't know what you don't know, and it may really come back to bite you guys. So as you guys are doing that, you're collecting the signature. To sum it up, get as much evidence as you can. Get the signature, terms of service, work that you performed, any chat logs, any email logs, any call logs, what was said. Typically keeping things in writing is a lot more useful than, well, when I was there, I told them this. Well, how do you prove that? How do you prove that? They send us stuff. So when you're doing change orders, if you're adding any dollars to any previously discussed amounts that's greater than what you originally quoted, those are really great times, because oftentimes they're like, I didn't agree to you doing this, and now you performed all this work and try to build me another $2,000. Just be very careful. You're kind of covering that.
Well, and if I could add real quick, because you touched on something that's very, very important, because I've seen it time and time again, and that is the cut and paste job. Very often, and I understand it, when people are in the same industry, they tend to borrow each other's contracts and then use it and modify it for their own use. And what ends up happening is it gets diluted time and time again. And I can't tell you how many times I've had a situation where I get a document to review, whether it's at issue, meaning that there's a dispute over it, or something to review it before they get it signed, and it doesn't even make legal sense. Key provisions were removed that, wait, this doesn't make sense to me. What's going on here? That kind of stuff. So very, very important to have an attorney review it if you can.
And it can be a lot more affordable than you may think. It's not going to cost you thousands of dollars for a simple thing.
Rocket Lawyer, exactly. If you use Rocket Lawyer, you do it on your own. You're saving money by doing it on your own and getting that far ahead. And then depending on your plan benefits, you have it reviewed. And in some cases, it's reviewed, for free, or at least a minimal fee or whatever it is. It's very, very cost effective.
Yep.
And you're going to end up saving yourself a lot of money in the long term if something does happen by doing it right the first time around.
Right.
Now that you bring it up, in our Facebook communities, I see all the time, maybe like once a week minimum, posting like, does anyone have a copy of terms and conditions? And I love that everyone is so giving and is like, here's what's working for me.
Right.
But that is like, please listen to Mario. Don't just copy and paste in there. Make sure you get a second pair of eyes. And then to Roland's point too, if you do use Housecall Pro, you can get signatures before and after the job is completed, and you can do that through multiple segments. So if something does happen with a dispute, you can go back and say, like, here's this person's signature, either electronic or in person. So
right. So another thing that's important too is check with your merchant service provider and see if your merchant service provider requires a copy of the driver's license of the individual, or a copy of the front and back of the credit card, or what have you, those kinds of things, to be able to sustain a chargeback dispute. I've had that happen even with with myself where they go, okay, well, do you have, the original signature and the original credit card? It's like, well, we do business up and down the state. We do businesses with people just on trust, DocuSign and stuff like that. And so that can be problematic at times also. So make sure that you comply with whatever those conditions might be.
So continuing on with other business issues, let's talk about independent contractor versus a full-time employee. This is probably the most talked about topic that occurs in all of our communities.
So it doesn't, just to clarify, it's independent contractor versus employee, not just full-time employee. Okay, so it doesn't matter if it's part-time or what have you. And so basically what you want to look at is, again, what I refer to as a Dynamex ruling, as well as AB5, Assembly Bill 5. And generally speaking, what that refers to is that there's what's called the ABC test. And so of that ABC test, the primary aspect of that test is, does the party performing services, is the services they're providing for you, is it the gravamen of your services? Is it an important aspect of your services? So let me use as an example myself. So if I were to bring on board, let's say, somebody to come in and handle calls for me on a part-time basis, 30 hours a week, just, do some intake, call people back, do calendaring for me, et cetera, et cetera. And let's say that individual works for 5 other attorneys as well, and she or he likes to be paid as an independent contractor. We sign an agreement for an independent contractor. Great. We work out a schedule. Perfect. The person likes it. Doesn't work that way, because that is an essential aspect of my business. Now, conversely, let's say if I were to hire somebody to come in and water my plants at my office. So that person's coming in, watering my plants, et cetera. That's an independent contractor. That is not an essential part of my business. That is the key element to whether or not that individual's an independent contractor employee. Along with those, like the other prongs of the ABC is that person independently licensed? That kind of thing. Does that person have its own corporate structure, their own clientele base, those kinds of things. And so, conversely, for example, with my firm, I could hire part-time attorneys, independent contractors. Why? They're independently licensed by the state bar. They have control over their cases. That's the other part, is control. Are you controlling the workday of the individual? If you're controlling the workday of that individual, that's an employee. Doesn't matter if they work 2 hours for you a week, 2 hours a day, full-time, part-time, that's an employee. What are some of the exceptions to that? Again, I just give you, let's say as an attorney in my field, but also if you Google or pull up Assembly Bill 5, it'll have a list of exemptions there too. Oftentimes like real estate agents, insurance agents, accountants, that kind of stuff. Typically people that could be self-licensed, that kind of thing. But in another, as an aside and an important aside, oftentimes I get questions, well, if both of us signed an independent contractor agreement and they agree they're an independent contractor and I agree, isn't that fine? No, it's not. Not in the eyes of the law. That is an invalid agreement. It can be invalid, even worse than, in my opinion, fines and penalties that you could face from, the EDD or the state or the franchise tax board for taxing issues and not, pulling out, the required withdrawals from, paychecks and stuff, is a possible workers' comp claim, because workers' comp generally doesn't cover independent contractors. It covers people on payroll. And so what happens typically, and I've seen it time and time again, is somebody's misclassified as an independent contractor. They had a handshake agreement or even a written agreement, independent contractor. That person gets injured. And then now what happens is they make a workers' comp claim, and now the company doesn't have workers' comp insurance. And now they're going to be on the hook directly for any claims that are paid out by the state. Because when there isn't workers' comp insurance, the state fund comes in, pays out those claims, and then they come knocking on your door with a big giant bill that I've seen in cases that I've worked on and handled, hundreds of thousands of dollars. And so why run that risk?
Yeah. I feel like normally we wait till the end for Q&A, but there's one here that's so topical because we're just talking about it right now. And so one of our guests, they chose to remain anonymous here, says, if you hire my daughter to work for my business, do I need to pay workers' comp for her, or should I hire her as a 1099?
That's exempt. So family members are exempt. So you can pay them with sand dollars, because it's a different policy behind a family-owned business where the family works together, cohesive, that kind of stuff. So you still got to provide PPEs, right? You still got to provide a safe work environment, but no, family members are exempt in that respect.
Mm-hmm.
Yep.
Nuclear family members. So, your son,
not like
daughter. Yeah, no.
Third cousin, twice removed.
Yeah, exactly.
Fifth married, whatever it works.
So Sean Kaplan has a follow-up question. Yes, true, but can't you do an individual workman's comp plan for the IC? They pay into their own workman's comp policy?
Depending on the insurance. So if it's truly an IC, first off, there's two categories. One is to make sure that it's truly an independent contractor, that it doesn't violate, AB5. Mm-hmm. If it meets that criteria and doesn't, then you'd have to talk to your workers' comp insurance company and see if they do cover that IC or under what kinds of terms and conditions they would cover the IC.
Mm-hmm. There you go. I'm learning so much.
So am I.
Thanks, Mario.
Let's go into this next one here. So when we're talking about, and I feel like this one's super controversial, in the world of COVID, you're interacting with customers.
Right.
You may have it, you don't know. The customer may have it, they don't know. What is the liability that our pros are potentially exposed to, and what kind of precautions should they take to make sure that someone doesn't either A, come back at them and says, hey, Mario, you gave me the COVID-19, man. Now I got all these medical bills to pay. Right. Or reverse, what if your employee goes, hey, Roland, you sent me in that home and you didn't do your due diligence and the lady had coronavirus. Now I got it. So
right.
What does this look like right now? And how worried should our pros be?
Well, we should all be worried in general, right? because of this new normal that a lot of people just know how to function in, and we're kind of just going as we go along and learning as we go. So for me, it's easy. I wouldn't say it's easy, but for me, it may be easier than others to relay what I think are the proper protocols to put into place, because I just use common legal principles on certain things, whether it be coronavirus or not. Think of it as like, are you sending your employee into a safe environment? So let's apply it to the COVID scenario. You're speaking with somebody on the phone, or you have reason to know that that person could possibly be sick, and you're sending somebody over there to perform a service, you can be liable because you had reason to know or should have known that was a situation. How can that happen? It's difficult to say like, oh, when she called in the order, she was coughing like crazy on the phone. But it could be that. It could be. It could be, and would it be worth that risk? Or let's say you're sending somebody to a nursing home to perform some work, and that nursing home has been hit with how many cases? That's easily, determined by a Google search that they've had active cases there. Again, same thing. And so, but then the nursing home comes back and says, oh, but we fully sanitized. We haven't had a positive case in a week, 2 weeks. All right. So are you willing to take that risk? And so for some people, it's, I'd rather have business with not having that risk, knowing it. And with others, it's like, look, I need to stay in business. I need work. Go ahead and take that risk. You will have to accept that liability on behalf of your employee, but that's where workers' comp comes in, all that kind of stuff. The unfortunate part about it is, even with COVID-19, is that we don't know to what effect, how it's going to affect that individual. Is it just going to be a bad flu? Is it going to be hospitalization, death? It's just, for some people, it may not be worth that risk, and just why even bother? So the flip side of it is, well, then I'd have to shut doors if I couldn't go anywhere. Right. And so, again, just using common sense and common legal principles where train your employees to look for certain key signs. Right. When they're going into an establishment or a residence, whatever the case may be. And that is, are they seeing even the homeowners not being kind of careless towards things? Right. If at any point in time an employee feels unsafe or whatever, it's just call it a day. Call it in, see if it can be resolved. But let's say, you have a homeowner, like when I've had people come over here and if I mentioned, when I first met you guys, I have a saltwater tank, right? And I have to get it serviced, right?
Mm-hmm.
So when that individual comes in to service it, we're geared up like it's outbreak. Him and I. The only missing are we look like those sumo wrestler outfits, right? That you go bumping into, that kind of stuff.
Oh my gosh.
And so, but it's not only, remember, the whole thing about wearing masks isn't necessarily to protect yourself, to protect others. And if we all do it, it's theoretically supposed to work. And so what I mean by that is, when that service provider comes in, he's wearing a mask. I'm wearing a mask so that he feels comfortable, and then he's wearing, we go a little bit further and he wears gloves or whatnot. And then, I sanitize and spray everything down, et cetera, et cetera. So it all boils down to what you do know on how to prevent the virus for yourself and your family. You should be doing the same for your employees. And you should be requesting the same of customers. when you're sending somebody out there to their household. So, when this whole thing started, another way of example, when I realized gyms were going to get shut down, I set up a home gym in my garage, right? And I had to have somebody come out and set it up. And this was before I knew you guys, or else I would go through one of your customers, your clients. But I forgot who I used, the name of the company, but nonetheless, they sent somebody out. And so I opened the garage at keep distance. When I engaged that person for any questions, I had my mask on. We kept our 6 feet apart. I offered water, cleaned down the water, provided any sanitation needs that he had. That's the best you can do. Does that make sense?
Yep. A lot of it boils down also to common sense, and then, always use the golden rule, so if you would like someone to behave this way with you, you should do it with them. Right. So the same that you would have people do for your family, you should also do for others' family, and vice versa. And ultimately too, it's going to be really, really hard to prove one way or the other. And if you're taking the necessary precautions, you're going to be pretty safe. Obviously there's always exceptions to everything, but with the state that we're in, it's going to be very difficult. And I can't imagine there's a lot of, attorneys out there that are even willing to try on those cases, especially not on an individual basis.
Right. But let me add to that. One thing that's very, very key, and you're right. And unfortunately, I have gotten a couple of cases of possible wrongful death due to COVID infection, where they believe that, there was as a result of one individual was at a hospital, not for COVID, goes in for a broken wrist, happened to be there. There was a COVID outbreak, and then the person eventually caught it and died, unfortunately. And so, I talked to my team of attorneys where we handle these kinds of cases, and nobody was interested in the case because you can't pinpoint how they got it. Did they really walk in with it? They were asymptomatic. They get it from somebody there. Is it just coincidence? Just the causation is key. However, what's very, very important is that as the state rolls out its different stages, is if possible, because I understand everybody has different unique needs, be patient and roll out at the proper stage. Where you will encounter most likely liability, in my opinion, is if you roll out against what the regulations are, what the rules are, in a stage that you're not supposed to be out in. In other words, you're not essential. You're conducting business when you shouldn't be. That just screams liability all over it if something happens, regardless of where the COVID came from, or that kind of.
Screams liability.
Catchphrase of the day.
Catchphrase of the day.
Causation. That's a good one. All right. So let's talk a little bit about money. And our pros, obviously, they're going out, they're doing the work, and now maybe they don't do COD. Maybe they don't get paid right on site. And they say, hey, you know what, Mario, no problem. I'll send you the invoice. You pay me later. All of a sudden now, they've got a past due invoice here.
Right.
And obviously there's the commercial side and the residential side. And maybe there's a little bit of difference in both in terms of things that you can do to, resolve the situation on unpaid bills here. But what are your recommendations there? Is it better to, have a local lawyer for these types of collections? Do you recommend going to a collection agency directly and selling the debt off? What are kind of like the steps? Because I feel like there's a way to escalate, what is kind of your recommendation around that?
Well, my first and foremost recommendation is get paid up front. Right, because it's never fun chasing money. It's never fun chasing money, and every industry is different. But my opinion, at least the opinions of my industry, is that the more you explain early on what services you're providing, and the more thorough you are as to what the customer can expect, because more thorough and the more you explain, the more that they're going to develop that bond with you from the get-go, right? That trust, so that if you do say, and we do require payment up front for our services, already now you're that farther ahead into them going, okay, I understand. As compared to not communicating early on what the extent of your services are, demanding for full payment, well, all of us would go, whoa, what's going on here? Why? I don't even know. We haven't even talked fully what you're going to do yet. So if you want to try to get yourself in a situation where you get paid first right away, which is always best, because then you control, those funds, unless it's a chargeback, right, or something like that. Then again, let's suggest that. Now, let's say that can happen and money's owed to you, or it's a change order, or it's a pay as you go, or it's a net 30, net 15, or whatever. So several things on that aspect. One is, back in the day, and a lot of people have it as like a common industry practice to go net 30 on payment. That was back when people mailed stuff. Mailed payment, right? The whole Pony Express, right? That you go check the mailbox. Now it's so different. Now net 15 is fine. There's nothing wrong with that. Net 15, another reason why Net 15 can be important is that you can almost, identify as a progress payment. So if it's an ongoing job that takes longer than 2 weeks to complete and they're having problems paying you by that Net 15, well, you can start doing damage control at that point. Right?
Yeah, you don't get too deep into it before you sink a ton more labor into it.
Exactly. And then also be very, very careful with a customer that goes, oh, please, the woe is me customer, right? Oh, just keep going. I'm sorry. I'm waiting for my stimulus check. It'll be here any minute. Before stimulus checks, I would get waiting for my tax return. I got you. And now you're spending time losing money, right, to chase it, right? Nobody likes that. So anyways, but let's assume the worst case scenario, you're owed money. Now what do? It just depends. It just depends on the amount, So, getting a lawyer, it's very tough to find lawyers, at least not something I would take, that would take a matter like that on contingency, meaning that we get a percentage of the fee. Why? Because it's not like a car accident case or something where you're almost assured payment by an insurance company. You're not. A person can file bankruptcy. You can get a judgment, but they don't pay it, and now you got to go chase them or chase their assets. And so, generally speaking, my thought process on it is, if it falls within small claims, you could ask for small claims assistance through Rocket Lawyer, where you pay a couple bucks. I mean, it's more than a couple bucks per se, but just term of art. Have an attorney help you review it, or maybe there's a small claims checklist on Rocket Lawyer they could use, something like that, and you could do it on your own. Small claims exist for regular people, non-attorneys, to be able to to go ahead with the process. And now with most courts, you can do it online. In less than an hour, you could have your small claims process, wrapped up, complaint sent out, or, lawsuit. And then next thing you get your day in court. Usually with the courts aren't impacted, probably within 45, 60, 90 days, that kind of stuff. That's the simplest. However, I get it. For a lot of people, they're very, very busy and they just don't want to deal with it. Well, then in that aspect, either an attorney that does take those cases on a contingency basis so that it's a win-win, and they'll take it and they'll just keep a percentage of whatever the reward is, or a collection agency that most of them that'll buy the debt off of you. And what I mean by buying the debt off of you, depending on the value of the debt and depending on the assets of the individual or business, that most likely that collection agency is going to make a determination on whether they'll pay you, and usually it's pennies on the dollar, right? So it's a big haircut. Speaking of haircuts, we're all due for some.
Yeah.
And so it's a big haircut, or they could take a large. Oftentimes I've seen collection agencies where they ask for a very large percentage if they're going to take on that risk of bringing the case forward.
Yep, because they're paying you out front, and then you can just skate away, and now it's assigned to them to go collect.
Yeah, in some, they'll pay up front, and then they own the debt, and you assign it. You never have to worry about it again. You already received money. In others, they'll want a higher percentage in exchange for taking all the risk of chasing this individual, pursuing them, sending out all those notices, default notices, that kind of stuff, and going from there.
Yep, that makes a lot of sense. There's some other, online options available. There's a company called Callbox out there that I definitely recommend. We aren't integrated with them or anything, but I've seen some pros have some good success with them, and they try to put some automation layers behind it with some increasingly aggressive emails, demand letters and things like that. So there's definitely some options out there for you guys before you guys go straight to small claims court, because obviously your goal is hopefully to get the customers to pay you. I've also seen another hack, which is, hey, you know what, Mario, I know you can't do the 10,000 upfront right now, and COVID happened. Why don't you do 2,000 now, 2,000 now? When you do that, make sure you get a good contract set up that outlines what is due, what, by when, who's paying what, and if there's any penalties, and maybe go get that fact checked by someone over at Rocket Lawyer. So that way, it's better to get something rather than nothing. So ultimately, you can always write off as bad debt, but don't try to go down that way. It's kind of
another thing that's very, very important. Very, very important is who is your customer. If you're dealing with an individual and you have to follow certain guidelines such as the Fair Debt Collections Practices Act, the Rosenthal Act, etc. If it's business to business, a little bit more of a whatever you want to say on the text, whatever you want to say on the email, try to get paid. Although I don't recommend it. I've always had taken the position if you get more bees with honey, if you make threats or what have you, people get very defensive, and then they start going, oh, go ahead and sue me. See what happens. But usually if you appeal to a person, if they do have some sort of a moral compass, you could likely work something out to some extent. But if it's an individual, you have to follow FDCPA, Fair Debt Collection Practices Act guidelines. Rosenthal, you could Google them. It'll tell you what it is, because the minute you go awry on one of those, it could invalidate the debt altogether. You can't enforce it.
Yep, and speaking of bees and honeypots, a great way to reach out to the customer.
The murder hornets? I thought we were going to talk about
exactly. The murder hornets, send them out to, put a little pot of them right on the doorstep and knock on the door.
Some there.
Yeah. But also too, sometimes, you know what, it's easy to tell a client, why don't you just give me 60% of it? You're in a hardship and I'll call it even. Right. You might just get 60%, which is way better than 0%. Right. And sometimes even if you're just breaking even on something, and you cut all your margin out, it's better to get that and just go to the next customer, because there's so many that are out there. Don't focus all this negative energy into one thing when you could be making so much more, ahead of you.
Don't forget the reviews. Don't forget that, if you don't approach in a way of you getting more bees with honey, you might end up getting that negative review that could cost you additional customers down the road. As compared to, let's say, if you do have a dispute, and let's say you're completely in the right, think of the long-term effect of, again, the adage of get more bees with honey, if just a softer, gentler approach and how you can work it out. Because oftentimes that individual, because most likely that individual is complaining for reasons that they shouldn't be complaining, is probably the person who's going to write that negative review anyways.
Yeah.
Right? And so, but oftentimes I've seen where those people at least add on there, well, at least we're able to work it out. They were very nice with me, that kind of stuff.
So Mario, I really like this next question, because something that we encourage our pros to do is post pictures of their work, post videos of before and afters. And this next question is there a legal document about like photo or media or testimonials to use them in my marketing, my website, or social media?
Right. So there is on Rocket Lawyer, I believe there's a template for it. You want to look for something that involves licensing or granting of rights, media rights, those kinds of things. So if you do a search term for that on Rocket Lawyer's website, you should be able to pop up with some sample documents. And it is very, very important. Ultimately, what it boils down to is, was there a reasonable expectation of privacy for what it is that you're doing for that individual? So let's say, for example, you're going into somebody's house, and you're going into their house and you're working on something that is in their house. Well, there's an expectation of privacy. So, to post your work and what you accomplished, and then, God forbid, in the background, you see somebody, or their portraits, or there's, pictures of their family now exposed online. You want to definitely shy away from those things. So you definitely want to get them to sign off on it, that these things, pictures of their work or what have you, could be used as promotional material, etc. But also, for you to really extend that service or that comfortableness with your client, show them what it is that you would post. So that they feel comfortable with it. If you're the customer, ask what it is that's going to be posted. So just assume that it's going to be fine, because next thing you know, something's posted that upsets one party or the other, and then that relationship goes sour. Yeah.
At Housecall, when we film our pros or use anything, we have them sign like model release forms. So that might be something different if the actual customer themselves is in it. It's not just like their home or whatever you are installing or fixing.
Right. And also, just don't take offense if they say no. Some people just don't want it to happen, and that's okay too.
Mm-hmm. That's a really good learn, I think, for me and everyone else here. I'm always like, snap away.
That's the world we live in now, right? Selfies and likes and media.
Yeah. I think you would find that most people are very reasonable individuals, and as long as you're not taking crazy private pictures of their pet foo-foo, line or something, like, they're not going to care,
Right.
So sorry, foo-foo.
Or to add to that, be careful on if somebody can determine where somebody lives easily, like an address or something like that. People see nice cars in the driveway, et cetera, et cetera.
PII.
That kind of thing.
So
good tips.
Yeah. Great tips. That probably is a big learn for me too, because I know now not to advise pros to just like take pictures and post it on their online booking pictures or things like that, or on their website. So I know we covered a bit of employment law in the beginning. This is one that has come. This is a question we got literally our first broadcast that we ever did. With everything going on in the world right now, what can I require from my employees? Can I make them sign some sort of work release form?
Well, if they're your employees, no, in the sense that, you could have them, if they're choosing to come to work, you could have them acknowledge that, we live in a time where they might be able to, they might catch COVID, that you're engaging in all of the necessary practices to provide them with PPEs. You could outline all that. Here's what we're providing you. And they sign out that they receive those items. That is very, very key, because the last thing you want is for somebody to come back and say, you never gave me a mask. Well, you signed off right here that you did receive it. So the receipt of those items is key. As to work release, you can't waive liability. You can't waive liability for your employees. Independent contractors, that could be a bit different, right? But you got to provide a safe work environment. So, if somebody came to me and said that, oh, they got injured on the job, whether it be COVID or something else, and then, we send a demand letter to the employer responds with, oh, here's a release that they signed, I'll invalidate it. I'll argue you can't release this employee. It's your responsibility.
Yeah, just remember, just because you put a piece of paper and you get someone to sign it doesn't even mean you can do that. Doesn't keep you safe. So don't try that.
And what if my employees won't come back to work? Can I take a temp? What happens here?
Yeah, very good question. We're getting that a lot now, right? So look, in something like that, it's no different really than whether it be COVID or not COVID. People don't come back to work for a variety of reasons. If they don't come back to work and it's not for a protected reason, such as something that's protected under what's it called, the FMLA, the Family Medical Leave Act, or something similar, because they got to take care of somebody that's sick with COVID, or they have a situation where the schools aren't open yet, so they have to take care of their kids, things of that nature that fall directly COVID related and are protected either on the state or federal level, then there's a certain amount of leeway that you have to give them. And I don't know the exact, how many days, weeks, or whatever, where they basically have either paid time off if it's your company policy, or they're entitled to FMLA benefits if you're 50 employees or more, or even, state benefits or whatever if, Governor Newsom has implemented those. But if it's a situation where they just don't want to come back, well, then that's their choice, but it's a terminated employee or a constructive termination. It all depends on if you're able to provide a safe working environment compliant with state and federal guidelines, and they choose not to come back, then it's an abandonment of position.
Yep.
Right? Without a valid reason, right? Without a valid, fear is a valid reason, don't get me wrong, but fear does not necessarily equate to an unsafe work environment, right?
That's right. Two separate things. So we had Mark Cuban on earlier. Wow, I'm going to say like week four or so. And one thing that he said, which was really interesting, is a lot of companies are going to a model where all employees or key employees have ownership stakes in companies. And I think traditionally, a lot of home service companies are just owned by the owner and everyone else is just the employee. And there's no equity stakes, things like that. Obviously, this is a key to true, wealth creation, not just growing, right? Because you're not just selling your time. So he brought this up, and I got a lot of questions from pros like, "Hey, Roland, how do you guys do it? Like, how are you able to give out shares? And can I do it with an LLC, or does it have to be C corp or S corp, or like, what is some advice maybe that you give to some pros that are looking to start doing this sort of a model where, at the very least, some of the GMs, the key employees, like the lead techs, actually get a percentage of the company, or maybe some sort of net profit share or something like that?
Right. So a variety of ways. It's a very specialized area of law, not one that I handle, but just as a general tenet and principles on it. First off is just be careful what you wish for, because you might get it. So if you make it so that an employee is a co-owner of the business, whether it be as a shareholder, like through an employee stock option plan, what's called ESOP, you could Google ESOP, ESOP, or if you're issuing, units in your LLC or some sort of vesting rights or ownership, that once they own that, they're now a co-owner of the company. You have a fiduciary duty to them, whether it's a minority shareholder or not, means that you cannot kick them out. And not all relationships go well. So if all of a sudden that employee doesn't perform and you want to fire them, okay, they're fired, but they own a part of your company. Still. So they're going to be entitled to, examining your books, dividends. And if it's a volatile relationship, the way it ended, they're going to go through with a fine-tooth comb when all of a sudden they get those reports and when are they getting paid out on dividends and et cetera, et cetera. Ideally, my opinion, and you bring up a good point with key employees, because of course you want to be able to hold on to those employees, hopefully prevent them going to competitive, industries or companies or what have you. Typically what I've seen people do there is you can create a bonus structure. You don't have to give them ownership. You just create a bonus structure that's tied into revenue, and so that way that bonus structure can be changed, depending on how you outline it in your employment manual or whatever it is that you want to do. And then also you could do what people also I've seen done is take out insurance policies that the company pays for that individual, that pays out their family, their beneficiaries in the case of disability, death, dismember, whatever the case may be. So again, that's another benefit in that they're not paying out of pocket for that premium. The company is, but their family, their loved ones will be able to, receive that benefit, right? And that goes along the lines of medical insurance too. Those kind of things that the more that you're able to support them financially without having to actually give them ownership of a company, that might be a better bet. Now, if you're set on, no, you really want to be a co-op in a sense and have co-ownership by the employees. Again, you can do that. Very specialized area. Something I have to go into, full details how to do it. You just got to be very, very careful because that opens up a lot of responsibilities when it comes to fiduciary duty and all that other fun stuff. And,
So this is definitely one which is a consult with your lawyer. Don't try to do this yourself inside of an operating agreement. Don't try to get fancy on it because you can create a lot of troubles for yourself if you don't do it correctly. Yeah. But I think the tips that you shared, which is like, what are some other things that can make an employee really sticky to you, like offering the benefits, the insurance pieces with beneficiaries, like all these things are better ways to start tying them closer to your company, and also just because you frankly you care. So when you show them that's gonna help, especially if that's what your goal is. All right, Alexa, I feel like it's 6 o'clock. It's top of the hour. We didn't even get to any of like the QAs that were asked on this thing. And we still have like so many on here. Let's see here.
Are you available for another 5-10 minutes?
Sure, let's go. Let's rock and roll.
Thank you. So, Roland, do you think we should go into the Q&As or one of these?
Let's do this one here. This one's a good one. And that's good.
All right. So this was a really good question we got asked on this post. It's a home service specific question. What is our exposure if a property owner who has dangerous or illegal electrical, plumbing, HVAC issues, and we do a minor repair, say replace a switch, faucet, or filter, however, they decline fixing the dangerous items and something happens later? Am I liable for that?
If it could be directly related to your work, yes, you can be. So again, it's where you make a decision at that point whether it's worth having that business or not, right? And so if it's something that can be dangerous, and by you manipulating it not in a bad way, but working on it, doing something to it that may be construed as adding to the issue or what have you, or compromising the issue, or putting another element on top of it, yes, you can have liability. Generally speaking, as attorneys, unfortunately, for those who pursue these kinds of cases where something happens and there's an injury, mainly it's usually when somebody, unfortunately, there's a big, personal injury, maim, death, or what have you, or a huge property injury, burns down the whole unit, the whole complex, whatever the case. You go after every single person that touched that item that led to it. And so because what you don't want, and some people may think, well, see, that's why attorneys are horrendous, they make our lives miserable. No. As an attorneys, we have a duty to do that for our clients, because what we don't want to have is what's called the empty chair defense at trial, where we assumed that one party wasn't responsible. So because they weren't in the lawsuit, everybody points the finger at that party, and now that now eliminates liability for the other parties, where in essence, if it was as a result of all of them, and what they did on that certain project. So getting back full circle to your question, the question here is, I wouldn't, if you see something that's dangerous and it has a direct relation to your work and work that you're going to do, I would not touch it. I would not touch it until it's brought up to code, whatever it is that the customer needs to do. And if they're getting upset, or if they want a really bad sign is if they go, I'll pay you more, I'll pay you double, just please do it. Bad sign. I've seen that happen. No, it never works out. Or I'll sign a waiver, I'll sign a release. Doesn't work out either. It referenced earlier, it doesn't matter what you sign sometimes. And this is one point I definitely want to make, because I get this all the time. You always, of course, you want to create your companies, your LLCs, your corporation, create that corporate umbrella. You want to have contracts in place, etc. Contracts, LLCs, none of it prevents lawsuits. Okay, it doesn't. So what it gives you are defenses. It gives you a framework to follow. And so along those lines, it's also very important to always be properly insured in your business. Because at the end of the day, even if somebody sues and you did nothing wrong, you want to be able to have the insurance company come in and pay those attorney's fees, pay the damages if there's any, so that it doesn't affect your day-to-day. It doesn't affect your bottom line and having to pay lawyers like myself or whatever. Except I'd wear a suit. I'd wear a suit.
Yeah. And umbrella policies that you have yourself too, don't just cover this. So don't just think because you have that, you're going to be saved by all these things. There's a lot of holes there too, especially when it comes to work, not personal.
Very important. If I want to add to that, what I tell people all the time is contact your insurance agent or broker. Tell them in writing what it is that you do and what you want coverage for, and then that way they respond and let you choose the line items that you want on your policy, because not every policy is the same. And oftentimes you can come across an insurance agent or broker, even online, where they're selling you the bare minimum because they want your business. And the bare minimum is going to have a lower premium as compared to, providing you with everything that you need. And then all of a sudden, they're afraid of losing you to somebody else with a lower premium. And so, not saying that they would do that on purpose or anything like that, but it's always important to put in writing what is your business does, so that you have something to show later on that you went to your insurance broker or agent and said, hey, I needed coverage for this. Why is the insurance company telling me I'm not covered?
Yep, that's very helpful. So let's go through Q&A, because we've got a couple ones in here we want to cover, and we want to be respectful of your time here too. Yeah. So the top question, do you want to ask the top question here, Alexa?
Let's see. Okay. So one of my contractors just got the PPP and one of his techs just quit. What should he do? Will he lose it? Does he need to hire someone quickly?
So PPEs have different parameters, right, that apply to it. And it can be specific towards the industry or specific to the paperwork. First and foremost is the contractor received the PPE has to read the paperwork that they signed. And it has to, there should be outlined in there certain terms and conditions as to how you can use that money for payroll and employment-related purposes to make it a forgivable loan or what have you. So that's the first and foremost thing, is just read the paperwork and follow. Of course people are going to quit. It just may mean that you didn't need a certain amount of that money to be earmarked for that person's payroll, but that doesn't mean that you can't use it for other things such as paying rent, overhead, other business-related expenses. It can possibly take a certain part of that money outside of the portion that's unforgivable. But again, you have to look at those line items to see how you could qualify, and also talk to your respected or trusted CPA or accountant to make sure that you have the proper record keeping in place, so that eventually when that note comes due, you can show everything that you need to hopefully have it forgivable, or the majority of it forgivable.
All right. I feel like we've always answered a lot of PPP questions too. Also, yeah. Swapping people out doesn't even have to be for that individual. Obviously,
yeah.
you could hire.
You're getting PPP money based on your payroll, but you're not getting it for each individual per se.
That's right. Mm-hmm. Yep. Or even the job function. So if you're like, I don't need that job function anymore. Yeah. We don't need installers because we're not doing that anymore. Maybe just repair.
Right.
You can do cross job types, whatever employees you want. It's just a dollar amount, really. Yes. The government's trying to make sure that you're keeping people employed doing something. They don't care what.
Yeah,
really.
You're not going out and buying a new car with it or giving yourself a raise with it or something like that. Right?
Mm-hmm. Yep. So one of the questions here in Facebook, we were talking a little bit about the family exemption. Is that for any state? Because we have that one, and then we have another one here in the Q&A that says, in Washington State, I understood immediate family needs to be on our state's work comp, regardless if kid's wife. Only if owner partner we can get an exemption.
Right. So I can only speak to California. So as far as I know, in California, I can't speak to other states, unfortunately. But it's an easy matter to look up online. Or through Rocket Lawyer, you could contact any attorney in any of the contiguous states, even Hawaii and Alaska, everywhere, and ask an attorney, to.
Because you'll get connected to someone that specializes in the state. That's what they do. And that's why it's very successful.
Sorry, Mario. That's why you see us like this, trying to read and sift through comments and questions.
Yeah.
No worries.
I promise we are listening.
We're scrolling through Facebook.
I just keep getting thrown off when Roland keeps going, Alexa, because I keep thinking, where's the Alexa?
Oh my gosh. my whole life now. In that same vein, how do I pick a local home service attorney?
So, obviously I can speak towards Rocket Lawyer, right? So you contact Rocket Lawyer and you go to rocketlawyer.com, go through this different prompts to contact us or what have you. And then you identify to them as to the area that you're in. So whether it be, California, we handle matters up and down the state. It could be any California attorney, but sometimes members like to have somebody specific to their county if it's a pressing issue that's county related, or sometimes it involves specific municipal codes. So you want to have an attorney that's familiar with those codes. But ideally, just contact Rocket Lawyer and then let them know what state you're from, what your issue is, and then they'll connect you directly with an attorney that handles that area of law in that state, or it could be an attorney not in that state but handles that state, those state laws, that kind of stuff.
Yep, because you could be licensed in multiple states. So you could be one attorney and you could have the entire West Coast or just California, Florida, Texas.
Right.
See that if you like taking the bar that many times.
Yeah. I don't know.
Mario, can I ask how many times you took the bar?
Oh, geez, what? I'm missing my connection here.
I think you said.
No, I'm kidding. I took it twice. I have no shame in my game. Yeah, so I took it twice, and what was so frustrating about that was going into it, was a group of friends and I that were studying for it. I was teaching them everything. I had everything going, and the mistake I made was sharing a room in a hotel room with a buddy of mine before the bar exam. I go to sleep. He turns on the light to study some more, woke me up, and then I freaked out. I couldn't go back to sleep. I was just a zombie for the rest of it. So the rest of it.
No.
And I did find out that I was only 2 or 3 points off from passing the first time, which at that time was an eternity, right? Because all my friends are moving on working, and at that time I was working for a big firm, and it was just, and I'm sitting there at home studying again for it, which is painful to do. And then, took it the second time, and everything's been great.
Flying colors. Look at you now.
Well, it used to be a lot harder than it is now. So yeah.
Yeah.
Roland, are there any other ones on here that you think are good for all of the pros?
Yeah, maybe here's one. So this is more of a general situation. So let's imagine that I do some work for another company, and I did it 2 years ago, and I never charged them for it because I was an idiot. And it's a big sum of money. What can I do? Do I take them to court? Do I ask them to pay me? What's the standard procedure? Or is there a statute of limitations on this?
Right.
So what is it?
Yeah, I'm assuming it's an independent contractor, did a work for another job and then didn't get paid on it, right? So if you have something in writing, it's called breach of contract. It'd be a breach of contract issue for non-payment. And so if you have a contract in writing, you have 4 years from the last missed payment or when you weren't paid. You made a demand to be able to sue to pay on it. If there is not a contract in writing, then you have 2 years. And 2 years, even if you have just text messages, emails, whatever, or just a handshake, it's just 2 years. And after that, if 2 years are blown, or the 4 years, play lotto.
SOL.
That expensive learning lesson, unfortunately.
Yeah, exactly.
Yeah, get on it. Don't let your invoices take that long to get sent out.
Mario
Go
says
digital.
Get paid now, not.
Yeah. Well, like I identified earlier, ideally, if you can, get paid up front, get paid now. And usually, again, what I've seen is that the more you explain your services, the more, depending on your reputation in the industry, et cetera, and then the demand that you're in, if most of your clients are willing to pay you up front now, why take that one case that won't? Why take on that matter? Usually that might be the problematic one, or the one that doesn't want to, stick with your guidelines.
It's like red flag.
You can offer things now like consumer financing if it's too big of a sum for them, or like Mario and Roland said before, I'll do 2,000 now, 2,000 later, or the 15-day. That's the first time I've really heard of the 15-day. It's either 30, 60, 90, which is an eternity to be paid for a big
Back in the day, I get it, but again, those are antiquated rules.
Yeah.
Antiquated rules.
Just because it's the industry standard at that time doesn't mean that you need to keep doing it. Get your money so you don't have to go hire a lawyer and go to small claims court.
Exactly. Now, the other thing you could do, too, to add to what you were mentioning earlier about, 2,000 now, whatever, is you could also, if you're willing, is discount fees for upfront payment. Right? And so if you have standard fees that are X or what have you, offer Y if you're paid up front now, or Y if you're paid 75%, Z, whatever. Or you could give a discounted rate, but if it goes into arrears, now the rate kicks up to normal, right? That kind of stuff. But you have to have all that stuff outlined in writing in your contract and your terms of service so that when it comes to enforcement, you're able to enforce it. Yep.
So obviously you've shared a lot of golden nuggets here for us. Our pros, I feel like we're going to keep that thread going on Facebook. They're going to keep coming in. We're going to start directing them over to Rocket Lawyer because there's a lot of great coronavirus content as well. We're going to share that link here in the chat for all of you guys. But what we're also going to do is we're going to include it in our blog post if you guys want to find out more later. And you want to peruse what's out there. There's a lot of great information there. There's the link for you guys. You guys will be able to go check that out. And you can also find Mario on there too. I'm sure you can get. My avatar. Yep, you'll see his avatar, and you'll see his haircut. So you'll find him on there.
It's Corona.
Yeah. Yeah. So thanks again for coming on, Mario. I feel like one thing we like to ask of our guests is, what's the one thing that our pros should be thinking about doing tomorrow if they haven't done it already?
Oh, man. Do we have another hour?
So there's lots of things.
Yeah. Okay. So what I would suggest doing is clean up your business to the extent that it needs cleaning. In other words, if before this conversation you've engaged in people as independent, having people work for you as independent contractors, but they were really employees, change that over. Stop the possible liability exposure now. If you haven't been providing PPEs in this new age of coronavirus, provide that information. If you haven't been providing terms and conditions on your contracts, you've been doing handshake agreements, go to terms and conditions if you can. That require upfront payments. Just slowly but surely implement the tips that we've discussed here. If it fits your model, it doesn't fit everybody, but if it fits your model, implement those, and little by little, you hopefully will have less headaches down the road, as we all do. And with that being said, oftentimes I've gotten the inquiries from people that go, I can't believe I'm being sued. What's going on here? And I have a saying, which is, if you haven't been sued yet, what are you doing wrong? Because this is California. This is how it happens. So don't fear. Don't get afraid. Don't become afraid if you end up in litigation, whether you have to sue or you're being sued. That's just part of what happens. So ideally, if I would say one thing that I emphasize all the time with small businesses or small to large, whatever, have adequate insurance in place. I can't tell you how important that is. Okay.
Well, thank you, Mario, so much for, I sent you a long list of questions and there were so many more on Facebook from that thread we didn't even put in there, but hopefully this answered a bunch of your guys' general questions. And Mario, you went wide and deep on them too. I feel like everyone should have some knowledge on those questions. And what we're going to be doing for you guys too, like Roland said, is we're going to do a little summary with all the questions that Mario answered. If you did miss this or you want to go back and see what he said. And I think the most important resource tonight, a lot of you asked for templates and documents. Go to the Rocket Lawyer website and you can search, I think it was at the top when I saw it, for different documents. Then you can go get them customized for your business. Don't just copy and paste someone else's. That is probably my biggest takeaway.
No copy paste. Copy paste.
No copy paste.
Copy and paste is only good for memes, right?
Yeah.
Right? Or copy and paste this now and you'll be blessed. Those, chain,
Oh my gosh. He agreed to $20,000 worth of work.
Exactly. Copy and paste, you're going to get a free Audi. Yeah, Mark Zuckerberg's going to get you a free Audi. Those copy and paste.
Bill Gates is giving out his billions, $10,000 if you copy and paste this.
All right. Well, thank you so much, Mario.
Thank you, Mario.
Appreciate you coming on. So cool for us. So cool for our pros. And we'll talk to you soon. Good night, everyone.
Bye-bye.
Bye, everybody.